I'm Scott Ott, and this is Bill Whittle Now. Bill, a little heralded news story this week from the Supreme Court where a unanimous vote was held in a case called New Prime versus Oliveira. And the thrust of the case is that the justices united to say that contract workers who are working for companies and not classified as employees, but contract workers, cannot necessarily be forced into mandatory arbitration agreements when they have a dispute with their employer, but they have the right, like others, to file suit or do a class action lawsuit. Now, the story that I read, which I believe came from Slate, yes, it was Slate on the 15th of January, focused on the aspect that a bunch of conservative justices who normally rule in favor of big corporations did not do so this time. Bill, does this surprise you that there's been a sudden lurch to the left among the conservative justices?
Well, first of all, nothing surprises me anymore. I think John Roberts' vote on Obamacare pretty much exhausted whatever, clutching of pearls and running to the fainting couch reactions I ever had as far as the Supreme Court is concerned. So obviously, let's talk about the deeper issue here. Look, collective bargaining and the ability to bargain collectively is, needless to say, I've seen an enormous amount of damage that I think that unions, particularly public sector unions, have done. But without question, collective bargaining is a right of any free people that are working. If you're at work and you feel the conditions are unfair, to say that you're not allowed to talk with other employees and then form a united front against this, that's just plain slavery to tell people they can't do that. But here's what I think the bigger issue is on this, and that is simply this. And I'm speaking from California, which, as always, is leading the nation, but in the last 30 years, leading the nation right off the cliff in pretty much everything that's wrong. As a person who's had to deal with this myself as an employer, here's the problem. It is the regulations, it's the insane amount of regulations, the insane amount of responsibility. If you have an employee, you send them across the street to pick up some pizza or something, and they get in an accident, your company is responsible, and all of this stuff. If the amount of paperwork and the amount of extra just plain sheer headache necessary, at least in California, to classify somebody as an employee is so overwhelming that it is turning the entire economy into a contract economy, because that's the only way business people can stay in business. And either you or the left saying that this is a victory for or voting against big business. Big business can afford these things. Big businesses have armies of lawyers that do nothing but arbitrate disputes and lawsuits and sexual harassment suits and all the rest of stuff. And when I say sexual harassment suits, I want to be crystal clear on this. There is no question that there is actual sexual harassment going on, although it seems to be less and less of it. And an actual sexual harassment case, somebody who I'm very close to underwent one of those need to be taken seriously. But there are also a very large number of just harassment cases where people are just basically, employees are harassing their employer. They want to quit. They make this threat. Here's $20,000, and be on your way. So what I'm saying is that as the government and generally left-wing politicians are making it harder and harder and harder to hire employees and all of the benefits that a regular employee has, more and more small businesses are forced into private contractors.
And here's the result of that, Bill. Let me give you a little bit of the particulars in this case. The plaintiff was a guy named Dominic Oliveira who went to work for this trucking firm called New Prime. And to begin his apprenticeship, he had to drive 10,000 hours, or at least be on board 10,000 hours as an apprentice without pay. Then there was 10,000 miles. And then there was 30,000 miles at $4 per hour. And then he became an official trucker with this firm as a contractor, not as an employee, but he had to lease his truck from the firm. He had to buy his gear from the firm. He had to buy his gas from the firm. Bill, it sounds like the old, Tennessee Ernie Ford song.
Oh, my soul to the company store.
Exactly. And so isn't that the risk of pushing people so far the other direction that we wind up with an old coal town, basically?
Well, I am freedom cuts not only both ways, Scotty. Freedom cuts every way. I have said repeatedly that if you want to run a bakery and you don't want to make a cake for people who you find morally objectionable, it's your business. You have the right to do that. They have the right to protest. I don't think they have the right to harass you out of business, but nevertheless, that's the case. So because I believed as a general rule, external what used to be regulation of maybe necessary regulations, which is now external to the company, crusades for the left-wing causes. What I'm trying to get at here is I'm saying it sounds, Mr. Oliveira, was it?
Yes.
It sounds like Mr. Oliveira found himself a particularly poor company that deserves to go out of business, not because of Supreme Court decisions, but simply because they appear from the outside, from the particulars you've given me, to be a particularly badly run company, and badly run companies in a fair market are put out of business by better run companies. The idea that you'd have to drive 10,000 miles without pay just to get started is telling me that Mr. Oliveira is probably looking at the wrong particular employer.
But I think a lot of people have been in this position, Bill, where you go to work and the only way you can go to work for this company is to be a contractor. And by the way, the particular issue in question in the Supreme Court case was none of the stuff I just listed, but rather the right of workers to sue rather than be forced into mandatory arbitration. So I'm going to sign that contract. I mean, the attorney sends over this long-winded contract, and you feel like, well, if I'm going to do this work, I have to sign the contract. And so the employee has no power. And what the left is going to say about this case is, well, it's about time that the Supreme Court started listening to the rights of the workers. But this case in particular is interesting because Neil Gorsuch, wrote the majority opinion, and he relied heavily on a textual analysis of the 1925 Federal Arbitration Act, which is the one that specified the different, what it said, employment. And he said, basically, if you look at the dictionary in 1925, employment means work. And there's no distinction between an employee today and a contractor when it comes to the right to sue. So,
what was the? Go ahead.
Go ahead.
What was the income tax rate in 1925?
Well, as I recall, when I was paying income tax.
What was it though when they announced the 16th Amendment? Didn't they say that the income tax would never amount to more than 1% for regular people and maybe 2 or 3% for the very rich? That was the absolute maximum that would be imposed. Wasn't that? It was
expected to be very small. Yes.
Yeah. Okay. So so there's a couple things in what you just said. While listen, I think these end user agreements on Apple, I know every time I click I agree on the Apple end user agreement, God knows what I have agreed to. But by clicking agreeing to that document, despite the fact that it's unreadable, it is still my responsibility. I have agreed to a contract. You may argue that the contract is unknowable, and that is all without question the case, but that's my responsibility. So when I hear stories about people saying, well, attorneys had a contract, the contract was very tough to understand. If you can't understand the contract, you shouldn't sign it, Scott.
But isn't that de facto collusion among businesses, Bill? Because all the businesses basically say, let's use this boilerplate.
Let me get to the point here, because I know that sounds heartless, but this is a personal responsibility issue. This is where all of this stuff starts, Scott. All of this freedom starts from personal responsibility. So when I hear people say, well, I signed a contract, but I didn't know what's in it, then you shouldn't have signed it, period. Okay, so let's just get that out of the way as what I think is probably the limit of this man's. Again, I've never heard the case before, but from the sketchy details I'm getting, let's just start with that as being his responsibility. What the Supreme Court is saying here, and what the left is rejoicing about here, is that they are gradually making a private contractor, subject to more and more and more of the protections of an employee, but at the same time, they're making it harder and harder and harder to hire employees, and so they're basically trying to have it both ways. If you look at the orbital picture, if you get way, way back on this, what's happening is the left has put in so many regulations, so many fines, so many additional costs, so many obligations on the part of the employer to hire somebody as an employee, that he's now forced to go to independent contractors because he simply can't stay in business otherwise. And now they're putting their finger on the other end of the scale and saying, well, even though it's an independent contractor, you also have to treat them exactly the same way as you would have treated an employee, at least in arbitration. And pretty soon there's going to be essentially no difference between the two, which is what they want. They want in exceedingly simplified terms, Scott. It is in the interest of the Democratic Party to basically say to every single person who signs the back of a check, we will write legislation that will protect you, give you more benefits, increase your pay if you elect us to office, and all of this is being done at the expense of the people who write the front of the check. And that's just a gross generalization, but that seems to be the case. I hear again and again and again and again and again and again, I hear more and more and more about employees' rights, employees' rights, employees' rights, employees' rights. And I don't see a single case of employers' rights. I haven't heard a single Supreme Court decision that comes down in favor of employers. In the back room, which you visited just a few days ago, is a gigantic plastic poster that is on the wall that lists in fine detail every single section of the California code that's applicable to all this. And if I don't have that on my wall, I'm guilty of a crime, and conceivably I could lose the business or go to jail. And if this was simple things like if the employer decides to make you work without pay, you have a right to redress, well, that's fine. But that's not what this says. You know, this is just gets bigger and bigger every year. Every single building in California, you walk into any building in California, you're required to walk past a sign that says this building contains chemicals known to the state of California to cause cancer if you feed 100 gallons of it to a rat in 3 days.
But certainly you're not coming down on the side of the corporation to say that we're going to deprive workers of their right to sue by forcing them into what can be a costly, lengthy, and unjust mandatory arbitration process.
What I'm saying is that if the world that the left is producing, let me rephrase that, not the world, if the business climate that the left has been allowed to get away with forever is drawing more and more and more enormous pressure on employers to hire contract employees. And if that means that now that they are hiring contract employees, the left is going to further insist that all of the benefits of actual employees apply to independent contractors, because that's what the term means. I am an independent contractor. I am essentially my own businessman. That's what the term means. And if you're saying that now this independent contractor who runs his own business is now subject to the same grievance protections as employees, then I'm telling you that if you take employees off the market and then you take independent contractors off the market, the only thing you're left with is not hiring anybody. And that's where you're going to end up real quick.
What the court and the left, frankly, in this case are saying, and I have one more question related to this that'll make you feel a little bit better, but what the court and the left are basically saying here is that some businesses, not all businesses, but some businesses like New Prime are trying to have their cake and eat it too by essentially not providing the benefits that an employer would have to provide, but assessing expenses on the contractor, making him pay for his lease, making him pay for his gas, making him pay for his gear, and having the source of all that stuff be the company itself. It just opens it up to corruption and to somebody essentially having a wage slave relationship, an indentured servant.
So of the two polar extremes in your argument here, wage slave indenture hood or mint or whatever on one hand, and excessive government regulations that are putting people out of business on the other, which one would you say is the primary problem in American society? Would you say that we have a problem with overregulation of business and overcost of business, or would you say that rampant wage slave exploitation?
I think it depends on which side of the aisle you sit and, frankly, which side of the check you sign.
I don't think that at all. What you're basically, what the left is arguing here, and apparently what the Supreme Court is arguing here, is that you've got a private company run by a private individual who's running a company that is, let's just say for the sake of the argument, without any further details, just plain miserable company. You have to drive 10,000 miles before, unpaid miles, and let's just say that you have to bring in a bushel of corn as well that you either purchase or grow. Let's just chuck it in there. These are the things that this trucking company wants you to do, and the trucking company wants you to genuflect when the CEO comes down the aisle, and any number of humiliations that you want to add to this. In my view of the world, while I don't find that attractive, I find the alternative less attractive. If I am going to enforce the fact that you can't make your employees genuflect in front of you when you walk down the aisle, I'm telling you how to run your business. And what I'm trying to get at here is not that everybody should be genuflecting. What I'm getting at here is that nobody should be working for a company that is run that badly. That company needs to go out of business, but not be put out of business by federal decisions or regulations. That company needs to go out of business because it's a badly run business. And to the degree that I am willing to work for a badly run business, I have no one to blame but myself. I'm sorry. I know that sounds heartless and cold, but it's the stone cold fact. When I hear people complaining about what a rotten, miserable business environment they're in and how terribly, awfully run this business is, and it's been like this for 20 years, my response to that is not, oh, you poor guy. My response to that is, well, why the hell did you put in the last 19 years and 9 months in a company that treats you so miserably? Because frankly, if this were the kind of thing, and most people do, by the way, most people leave badly run companies so that they can go out of business the way they're supposed to.
Let's end on a high note here, Bill, because I think there's one aspect of this. Go ahead.
Well,
go ahead.
Let me just close one thing. This is what freedom is, okay? Freedom is this. This is freedom. This is what a free society looks like. I get a chance to start a business for whatever reason because I have the resources or whatever. I'm going to write paychecks to someone else. In a free society, the best businesses are the ones that treat not only their clients the best, but their employees the best. Their employees are their primary resource. If I'm stupid enough to be silent agree and make my employees, give them this kind of Bob Cratchit existence, you can take a half a day off on Christmas kind of thing. If I'm going to run my business that way, that's my business. And if they want to work for me, that's their business. There's nobody forcing them to do it, and it's not like this is the government business to which there is no alternative. So that's my end of the freedom as an employer. Their end of the freedom as an employee is to improve their condition in a free market. And if it turns out that every single business requires 10,000 hours of unpaid
miles
apprenticeship, if it turns out that every single if it turns out that every single trucking company out there requires 10,000 hours of unpaid miles as an apprentice, then you have to accept the fact that that is the cost of the occupation that you're looking for and start getting your 10,000 hours in. I've seen helicopter pilots. I've known them personally who are flying jet rangers. They're flying jet-powered helicopters. They're making significantly less money than an Uber driver. Or I've seen people working at flight schools who are working at considerably less money than an Uber driver, or a barista for that matter. And what they're doing is they're putting in their 1,000 hours of flight time, because at 1,000 hours of flight time as a flight instructor, then they can start in the right seat at regional airlines. And if they don't like it, I'm not happy about it. It doesn't make me happy to see my friends working for nothing. But that's the market. And if you want to be a pilot, then that's what you're going to have to do. And if that means you're going to have to be a waiter in the daytime or nighttime so that you can put your 1,000 hours of sub-pay work in as a flight instructor so that you can get the job you're looking for, that's the compromise and the decision that many people make when they truly want to be.
Well, here's the thing that kind of surprised the writer at Slate. Neil Gorsuch, who wrote the majority opinion, went through a rather tortured, lengthy analysis of terms like employment and work and contractor, and tracked that back to the 1925 Federal Arbitration Act that sets up this whole atmosphere where people go into arbitration instead of going to court. And the Slate's writer said basically Neil Gorsuch used his textualist bent or principles to lead to a liberal conclusion. Bill, isn't that exactly what textualism should be all about?
Yes. Not to lead to a liberal conclusion or a conservative conclusion, to lead to a constitutional conclusion. I understand that precedence is a large part of the law. I do think, however, that if you have a precedent that is set and that precedent is unconstitutional, illogical, or just plain stupid, then there comes a point when you need to break with precedent. And chief among these is the Commerce Clause, which is an entire hour discussion as it is. But when a prior court rules that Congress, which in the Constitution, according to the Commerce Clause, has the right to regulate trade among the various states, foreign powers, and Indian tribes, when a precedent says that, oh, and not only do they get to regulate, which means make even, it doesn't mean control, it just means make fair. When they decide that Congress also, in addition to being foreign powers, Indian tribes, and other states, meaning the state government, when somebody interprets that to mean, oh, and also regulate all the commerce between everybody within the states, then that's a precedent that needs to be overturned. But I would rather have constitutional judges who are following the letter of the Constitution and applying impartial, timeless views of jurisprudence that respect the Constitution and follow it to a conclusion. If that conclusion is a conclusion that progressives like, then I would much rather live in a world where every 50th decision reached by constitutional means helps the progressive cause, rather than a Supreme Court that's decided that the Constitution is a historical document suitable for framing, like Washington crossing the Delaware, and will make a decision based on how they personally feel at the time.
Bill Whittle Now comes to you 5 days a week with Bill's take on the breaking news stories of the day. It's made possible by the members at BillWhittle.com who have gone to BillWhittle.com and clicked that Become a Member link and signed up to become a citizen producer of this show. We appreciate their effort in this enterprise. We couldn't do it without them. So for Bill Whittle, I'm Scott Ott. Thanks to the members of BillWhittle.com for making this possible.